decision open, though, Gruden said that, as you know in life, you never say never to nothing. Reports have surfaced that Gruden is purportedly contacting potential assistant coaches that could join a Gruden coaching staff. Gruden's name has reportedly been linked to the Tampa Bay Buccaneers head coaching job, as well as at Tennessee, a position Gruden has had before in Tampa Bay. ESPN is reportedly going to let go another 100 staff members after Thanksgiving. The network laid off around 300 employees in late 2015 and another 100 earlier this year, most of which were on the air talent. That report, according to a story in Sports Illustrated last week. Sam Jordan, News Talk 92.7 Sports Now.
Clouds will gradually increase out there through your afternoon. Not bad, though. Highs upper 50s to around 60. Tonight, cloudy. Can't rule out a sprinkle or light shower, but not much. Lows mid and upper 40s. For Thursday and Friday, looking good. More sunshine, milder highs into the lower to middle 60s. To relieve muscle cramps in your legs and feet, use ThoroWorks Relief. This fast-acting foam is clinically proven to relieve leg and foot cramps. Get ThoroWorks Relief today at select CVS and Rite Aid pharmacies. And I'm Sorky, Chief Meteorologist at your core.
Broadcasting live to over 1 million souls in Chattanooga, the Tennessee Valley, and beyond on frequency modulation 92.7. Sean Hannity, 25,000 watts on digital FM 95.3 HD4. CBS Radio News, NASCAR, Bloomberg Markets, David Tulis, streaming strong at Noogaradio.com. Live on YouTube and Facebook. Nooga Radio, News Talk 92.7. Chattanooga Radio.
Good morning, Chattanooga. This is Jim McKoon, and welcome to another edition of Legal Bytes, the show where we come on weekly to talk with each of you, the listeners, about legal issues and events that could affect and impact you in your personal lives or in your businesses and your planning, whether it be for taxes, for estates, or just in business issues. And my co-host today, Clay Whtaker. How are you doing, Clay?
It's a good day today, Jim.
Good day. Well, it's a good day for us, but it's a horrible day in California.
That's what I hear.
Yeah, I don't know what's happening to this country and to this world with all the shootings that are occurring, but with the things that are happening, it made us start talking about a topic for today's show. And really that goes to wrongful death and wrongful death claims.
Well, wrongful death's a big topic, Jim, and it addresses a number of things, but it cures usually this is a statutory cure, but it's a statutory cure that allows people to continue lawsuits or to file lawsuits for persons who were killed or died as a result of the wrong from some other person.
Right. And as you point out, it's statutory. The common law, which was the law we came here from England with, and the law that is developed in the courts, the common law said that when a person died, their claims died. So there was no right of action for someone who was passed. But our legislators in all the 50 states have created what we refer to now as a wrongful death statute that creates a cause of action and basically creates a survival. But since it's an derogation of common law, you have to go with what specifically the statute provides. And each of the statutes, at least in the surrounding states we have, provide when you have a wrongful death cause of action, and they're consistently, although they say it differently, refer to the cause of action for death. For example, in Tennessee, it says the right of action that a person who dies from injuries received from another or whose death is caused by the wrongful act, omission, or killing by another would have had against the wrongdoer in case of death had not ensued, shall not abate or be extinguished. So basically, if you hadn't died, could you have sued him? Well, if you could have, then you can still, the person can still be sued for causing your death, but it has to be brought a certain way. In Georgia, it refers to the liability for the homicide of a person. So, I mean, it's different language, but the same effect. It gives us a right or a cause of action that where a tort or an act, a tort being a breach of a duty to someone negligently, usually, but also could be intentionally or statutorily, but where that act caused the death of the person, and therefore in Tennessee and in Georgia, although it's written a little differently, effectively you've got the surviving spouse, surviving children, or the parent of the decedent can bring the action, and there's a hierarchy generally in the states as to who can bring it. And then it also provides what happens to the funds. And also you can bring it through an administrator if there was no will, or you can bring it through the executor or executrix, whether it's male or female, of their estate, if they had a will that was probated, so that you can bring those cause of actions that way.
Well, Jim, we're following our new format. So all the listeners, our number is 800-8949. This is the topic today. It's wrongful death. We're talking about it in the state of Tennessee, the statutory provisions here. Those are in Georgia and also in Alabama. 800-8949. This is Legal Bytes. Clay Whtaker and Jim McKoon here talking about these legal issues, and we'll talk about any topics that you'd like to call us about. Give us a call. If you're listening to the show, our faithful listeners, we really appreciate you paying attention. And let's get into the meat of the subject. Jim, I think you introduced it pretty well. So, when you're talking about wrongful death, one of the issues is, and I think you've already said this, is that who can you sue? So, you can sue the people that either intentionally or negligently harm you.
Right, and it doesn't have to be an individual. It can also be a corporation or other legal entity, such as in a product's case. If someone's harmed by a product, and as such as either you hear a lot today, and we're actually involving one. Hold on a second, we've got a caller. Let's see what we've got here, Clay.
Well, you were talking about the issues related to products. So
yeah. Hello, caller. This is Legal Bytes. How can we help you?
So wrongful death products, and now I hear they're trying to make every single toy out there a hazard. So if a kid gets let's say a widget and sticks it in their mouth and chokes, is that company liable, or is it just the parent not paying attention, or maybe is it just an accident? And I have another question for you.
Well, that truly depends upon what actually happened and whether or not, one, there was a warning, whether it violated any type of standards in the industry, whether there was a misuse of the product, clear misuse of the product, whether there was the lack of supervision. Tennessee, for example, is a comparative fault state, so you might have issues going to that. So
you think we're going too far? Because I could see, like, if it's a crib and the kid rocks on the crib and the side caves in, then obviously, we can see maybe it's a manufacturer, but to me, it almost looks like we're going too far on this. And I have one more question as far as liability with death. Do the citizens have any cause of action and legal recourse when government kills people? Let's say in Colorado with the guy with his hands up, they were found not guilty in the government. The cop executed him point blank, and death by government. Let's say Bill Clinton murdering 76 people in Waco, Texas. Has there any recourse of the police state murdering common citizens?
Yes.
And I do know people realize they're slaves and we're in the police state. So, other than revolution that's going on right now, what recourse do we have?
Let's go back. First, you say you think we're going too far with protecting children. You will feel that way until it's your child.
Oh, no, I have children.
I understand, but if it was your child that was harmed,
I don't need the government or a manufacturer telling me what I need to do or not to do.
Well, no.
Americans have become stupid.
That's not the issue.
I know.
It is not an issue.
And I know if something's too small, you don't put it near a child.
But caller, that's not a product's claim when you're talking about a child being hurt. That goes to misuse and the parent's negligence. It's more an issue where there's a...
Well, let me ask you this. What about baby food? Now, we're now finding that in our CBS radio news on your radio station said that 80% of all baby food has arsenic in it.
Well, caller, I think this was the issue, is that while you may have a point, at least, in regards to Americans being sort of captured by the nanny state, as you might argue.
Sure.
But one of the things that I think is important to remember is that these laws and lawyers who are involved in prosecuting these cases many times are the ones that uncover fraud and uncover wrongdoing by corporations. And corporations, I think the latest issue that I can remember, certainly the baby food issue might be one that will ultimately turn out that way. But what about the melamine or the Chinese wallboard that was put into these homes? Many manufacturers look for cheap ways to import products or to bring products to the consumer who would otherwise have no knowledge about the dangers that are posed, were it not for either attorneys bringing these lawsuits to find these things out, to uncover the wrong that's been done, to protect lives, and to recover from the loss that's been done to families and to communities, or the government itself is involved in uncovering some of these things. So, I think that's where we are.
You
don't even have to go that far. You've got lead paint poisoning. You've got asbestosis, the probable asbestos in the homes. You can keep going on and on and on.
People need to use more common sense too, and not expect to be. I think it's a false sense of security.
You don't have to. People don't have to. Our courts
going to be there to protect them.
Our courts and our laws will use the common sense, and the attorneys that are engaged to do the investigation. I mean, that's already happening. There are a number of cases that are not brought. Improper cases are denied or dismissed. I mean, so I still believe in our system of justice. But I mean, for example, the baby powder situations. Who would have thought that baby powder that you put on a child's bottom that you use to stop chafing would cause women to have ovarian and uterine cancer? I mean, but the fact of the matter is, in 1971, Johnson & Johnson and the industry knew that talc was being found in the tissue of women who were having surgeries as a result of uterine cancer.
I'm going to throw out a crazy speculation, and it's just it's not even a hypothesis; it's an opinion. Cigarettes definitely kill people. There's unquestionable evidence to show that it's a device that will kill you. You will die if you smoke cigarettes or something related to cigarettes. But the chances are you're 10 times greater. Why do these companies? Why are they allowed to exist? Why cannot consumers bring suit against them? My dad died of cell cancer. He smoked 2.5 packs a day, caused by cigarette smoking. Back in the day when they said it was safe to smoke. How in the world did they get away with this? How did they get away with pushing this poison when there's overwhelming evidence to show that it's going to harm you? That is beyond me.
Those claims were already with fluoride. Caller, those clauses were already brought.
Yeah,
those claims were already.
My hypothesis, my guess is maybe the government knew this years ago, and knows by the time you turn about 65, you're going to die anyway, and they don't have to pay out Social Security. I mean, it sounds kind of crazy, but so many people I know that have gotten cancer have died have been between 60 and 65.
All right, caller, we'll respond to you off there, and then we'll go forward. So, all right, well, Clay, what he's raising, those cases have already been resolved. Those people are the people that were smoking when there were no warnings, there was heavy advertising, there were efforts in the advertising in the marketplace to induce people to smoke. Those claims have already been brought. For decades now, we ceased the advertising. We have warning labels on the cigarettes. And this is America. You can make your own choices at that point in time, but if you choose to smoke, that's the decision you've made with the warning that is out there and with the knowledge that's out there in the community.
Well, and I think that the caller is wrong in one sense, is that, Americans aren't completely a bunch of ninnies that don't know what's going on. They're able to watch out for themselves. Obviously, the caller thinks he's one of them, and I think there's a large number of people that certainly, they may be known by a number of different names, but certainly have the idea that they can look out for themselves. But what we're talking about are the circumstances where they don't have superior knowledge. The knowledge is contained by the corporations or by other powerful groups that have the information. And so when you bring these lawsuits, example, certainly at one point in time, the smokers were being duped and were subjected to a terrible product that caused these deaths.
Right. You're more of a man if you smoke a Marlboro.
That's right.
That kind of thing.
And that guy died. We know that the Marlboro man himself died of horrible cancer. So, that's a sort of circumstances where we're talking about equalizing the playing field. The consumer themselves is not in the same, at least, power with regards to the knowledge. And the law looks at that and takes that into consideration. And that was the first point. And I think that sort of answers that issue for the caller. Second problem the caller brought was about death by government, I think is what he quoted. I think that what we have is the 8th Amendment, and you're talking about excessive force, and there are a number of statutes to deal with that. Our law firm handles those kinds of things, as well as the products liability actions, where we try to equalize the playing field that deals with the situation where the consumer's not doesn't have the knowledge, has not been warned, and is taken advantage of, causes terrible injury or death to the consumer.
Right. So, I mean, yes, the 1983 federal statute gives you claims where there's been an excessive force situation. You can bring the action. So, yes, you have a remedy. If, for example, let's not talk about Donald Trump going out and killing 42 as the caller used example. I think we have to bring this into reality, caller. What we're talking about is a situation where an officer improperly draws his weapon, even if he doesn't shoot, or if he shoots to scare and doesn't cause physical harm, that is still a situation that can bring a cause of action. But in most situations, and situations we've had in our offices, there's actually been a use of force that has caused an injury to the individuals.
That's right, Jim. So any callers that want to talk about these subjects, we're going to continue to describe the sets of circumstances where you can bring wrongful death cases. Call us at 800-8949. We're going to carry on with our conversation. So, Jim, one of the things we didn't get into before the caller talked about, maybe this was a good time, is about the kinds of tortfeasors. So we talked about those people who were intentionally injuring people, for instance, the shootings that have been going on. If the estates of the persons who've been involved in shootings are at least substantial enough to be able to make a claim against, you might be able to bring a wrongful death suit against those folks in Texas, or now we've got the terrible incident now in California, or even in our own state. Let's don't forget that in Antioch, Tennessee, we had a shooting involving a young man who killed some folks at church.
Right. Or you bring it into a more difficult situation to the individuals. The attorneys know how to handle is a situation where maybe there's a terrible car wreck, and the person who caused the car wreck that killed your loved one was also killed. What do you do? And there's no estate open. And so how do you handle that? And there's a procedure in Tennessee whereby we set up what's called an administrator ad litem. We actually have a stakeholder set up by the probate court of whatever county they lived in, who is available to receive, service, the process, so that you can access the insurance that the tortfeasor may have had available, so that you can start a cause of action, so you can try to access, if necessary, your uninsured or underinsured motorist coverage, and so that you can also access any rights for causes of action you've got against the assets they had in their estate or in their name at the time of death that are not being made available because the beneficiaries or their loved ones have decided not to open an estate. So, there's a procedure whereby we can do that in Tennessee.
Well, Jim, that's what it brings up, and I think the caller was kind of touching on this, is that, there were some concerns about these kinds of lawsuits and whether or not these things are necessary. Like you mentioned to the caller, where it's your family that's involved, where there are children that are left without parents, where you've created a void that can't be filled because the economic loss is so great. You need these kinds of lawsuits. You need this statute. That's why it was created. I mean, a lot of people, I think, get the idea, well, lawyers got together and created this so they can make more money. And that's simply not the truth. The idea here is that we protect those, particularly the innocent, and those who are unable to protect themselves.
Right. And it also, when you talk about the damages that are recoverable, they're different in each state. For example, in Tennessee, it's the economic value of the life that was lost. In Alabama, it's measured based upon punitive damages. It's truly a punitive award. How much does the jury feel the defendant should be punished, i.e. how much should be awarded against that defendant for killing this individual? In Georgia, it's called the full value of the decedent. It's shown by the evidence. So it's a little broader than it would be in Tennessee. But, each state is trying to create a way where you can try to replace what that individual's worth was to the family and to his loved ones. But then on top of that, you've got additional claims. You've got the consortium claims. And in Tennessee, our consortium claims are so much broader in a wrongful death scenario than they are in any other cause of action, because in when you normally talk about a loss of consortium, you're talking about a claim between a husband and a wife. And so you see this often where maybe the husband was hurt and disabled. And so you're talking about the loss of services that a husband maybe does in the partnership of a marriage, but you're also talking about love and affection, romantic relations and the like that are all disrupted based upon the injuries. But you normally don't see a situation where a child and parent have a claim of consortium, even though we all know it exists. We all recognize that there's love, affection, and that parents do things for children and children do things for parents in a family home. But that, and it's referred to as filial consortium. Filial consortium does not exist in a normal cause of action in Tennessee, but it does in wrongful death. So you've got a claim as a parent for the loss of your child that's individual to you, not for the wrongful death value, but also for you have that, but you also have the loss of consortium, the loss of the love and affection of the child that was killed, perhaps. And the same for the child to the parent. And that's recognized as the courts have interpreted the statutory language within the Wrongful Death Act, because as I said, remember, it's derogation of common law. So any and all rights have to be within the act.
Jim, I was going to ask is our listeners out there who may have a concern about one of these cases where loved ones may have passed, they believe a product might be involved in it, or someone has injured them in the course of an accident or some other thing. How do you know when to begin your lawsuit? We have statutes of limitations in all three of these states. What is it with regards to these particular kinds of cases we need to be aware of if we're protecting our rights?
Well, I mean, first you've got to look to when was the actual injury. And because by a lot of causes of action, it's from the time of a complete cause of action, which requires damage as well. Sometimes not. Sometimes the cause of action, and it depends again on the type of the cause of action. Sometimes it occurs at the time of the act of which you're complaining. So you've got that. You also have the discovery rule in Tennessee. So if you just discovered that there was an injury caused by some product, for example, we've got cases in the United States right now, going back to this baby powder situation, where women are just now finding out today that, one, they've got cancer, and two, that there was a likelihood, depending upon the pathology, that the cancer was caused by the talc in the products they purchased. And as a result of that, they are able to bring cause of action, not because they're still within a statute of limitations, not because they're within what's called a statute of repose, which is the last date you could bring an action for once a product goes in, usually into the marketplace. But it's all because of the fraud that was perpetrated allegedly by the manufacturers by hiding material information regarding the harm that can be caused by the ingredients of the product that they're putting into the marketplace. And they're in, sprinkle a day keeps odor away, all the jingles they use to try to get women to use the product and to buy the product. Although they knew, going back, like I said, as early as 1971, that there was a hazard in the ingredients they were using.
Well, our office is 756-6400. It's McKoon, Williams, Ashman, Stanley. If any of our listeners have questions about this very complicated subject of when your lawsuit accrues, that's the way that we would coin that phrase in the legal practice. That is, when do you have to sue by, or when is your case barred by any statute of limitations? Give us a call. We can talk with you about that, learn the facts from you, give you an opinion about when you may have an action. So 756-6400. We can talk to you off the air about that. If you want to talk about other topics, we're getting ready to come to our break, but it's 800-8949. We'd love to talk with you about any topics. But we're going to continue to talk about this very interesting subject of wrongful death.
Right. And, one of the things that these people, people in the audience need to understand is as a plaintiff, time is not normally on your side. The laws are set up. Tennessee has, probably the shortest statute of limitations in the nation at 1 year. You go to Georgia, it's 2 years. I think North Carolina has a 3-year personal injury statute of limitations. I think Alabama has a 2-year statute of limitations. But Tennessee, we have a 1-year statute. But even though you may be within your 1-year statute of limitations or within your 2-year in Georgia, that does not mean that you still have a valid cause of action. And that's because of what I just referred to earlier. That's the statute of repose. For example, let's assume that you're in a car, and your car, and I know we're almost at half hour, and I'll finish this up maybe on the other side, but we'll just hold that thought. Assume you're in a car and that there is a horrible accident. Keep that in mind. We'll talk about it in just a minute. This is Legal Bytes. Thank you for joining us today, and we'll talk to you on the other side of the hour.
The Tennessee Valley's news talk leader, Nooga Radio, digital FM 95.3 HD4 and 92.7 FM. Chattanooga Radio, digital FM 95.3 HD4, 92.7 FM's news. Now,
a major drug bust in the Chattanooga area. The Lookout Mountain Judicial Circuit Drug Task Force executed a search warrant at a home on James Street in Rossville, Georgia, and police say that they found 8 pounds of methamphetamine and 5 pounds of high-grade marijuana. 2 individuals were arrested, and now the search begins for their supplier. The city council voted 8-1. You're going to be able to drink beer on Station Street in between the Terminal Brew House and the Chattanooga Choo Choo, but that's the only place you'll be able to carry your drink outside. City council voting 8-1. Chip Henderson, the only no vote. The ordinance will go into effect in 2 weeks, and patrons will be required to carry special cups labeled Terminal Street. A jury from Chattanooga has been assembled to hear the Holly Bobo case, a murder case out of Hardin County. Dylan Adams set to stand trial May the 29th, 2018. Russell Stroud, Nooga Radio News Talk 92.7. Now,
traffic, news, and information. Nooga Radio, digital FM 95.3 HD4 and 92.7 FM.
Sam Jordan, News Talk 92.7 Sports Now. John Gruden, who's been tabbed a leading candidate for the Tennessee Vols head football coaching job, has alluded to a national radio show on Wednesday morning that he does not plan on leaving his job as a color analyst on Monday Night Football. But he left the decision open, though. Gruden said that, as you know in life, you never say never to nothing. Reports have surfaced that Gruden is purportedly contacting potential assistant coaches that could join a Gruden coaching staff. Gruden's name has reportedly been linked to the Tampa Bay Buccaneers head coaching job, as well as at Tennessee, a position Gruden has had before in Tampa Bay. ESPN is reportedly going to let go another 100 staff members after Thanksgiving. The network laid off around 300 employees in late 2015 and another 100 earlier this year, most of which were on the air talent. That report, according to a story in Sports Illustrated last week. Sam Jordan, News Talk 92.7 Sports Now.
Clouds will gradually increase out there through your afternoon. Not bad, though. Highs upper 50s to around 60. Tonight, cloudy. Can't rule out a sprinkle or light shower, but not much. Lows mid and upper 40s. For Thursday and Friday, looking good. More sunshine, milder highs, and a little more to middle 60s. To relieve muscle cramps in your legs and feet, use ThoroWorks Relief. This fast-acting foam is clinically proven to relieve leg and foot cramps. Get ThoroWorks Relief today at select CBS and Rite Aid pharmacies. And I'm Snorteen 12, Chief Meteorologist at your core.
The Tennessee Valley's news talk leader, Nooga Radio, digital FM 95.3 HD4 and 92.7 FM.
An automated nuclear missile defense system has suddenly entered into launch mode, and you are the only one who can stop it. Escape Experience Chattanooga. Your team has just been infected with a deadly virus. Your only hope? There, an abandoned farmhouse. Escape Experience Chattanooga. Handcuffed in a maximum security prison, you have an hour to flee. Escape Experience Chattanooga. These escape scenarios and more at Chattanooga's best escape room, game, and team building platform. Call now. Slots are limited. Register online at escapeexperience.com/Chattanooga. Escape Experience Chattanooga.
On Thanksgiving, we give thanks to our bountiful blessings. However, there are those who are not so fortunate. Homeless military veterans deserve honor, respect, and at least some of the basic necessities of life. Hi, I'm Summer, inviting you to share the gift of caring. We at Summer Cares are collecting shoebox items that will be given to homeless military veterans at the community kitchen in Chattanooga.
What would go into these shoeboxes?
Toothbrushes, toothpaste, dental floss, deodorant, chapstick, cosmetics, shampoo, soap, hand warmers, hand sanitizer, socks, gloves, toboggans, small Bibles, blankets, snacks, and cough drops.
Where can people donate these items?
Alpine Crest Elementary School, Sonic on Hickson Pike, Chick-fil-A in North Cape Mall, Greg's Sandwich Burst, 6337 East Brainerd Road, and Nooga Radio. The two words that should never go together are homeless veterans.
Nooga Radio, Digital FM 95.3 HD4 and 92.7 FM knows your opinion is important. So call 800-8949. Agree or disagree. Call 423-800-8949. 800-8949. Nooga Radio, 92.7 FM and 95.3 HD4. News Talk Nooga Radio.
Welcome back to Legal Bytes Chattanooga. This is Jim McKoon and Clay Whtaker, and we're talking today, among other things, the rights and causes of actions that individuals have as a result of a wrongful death claim, and how the statutes in the various local states affect what those claims are, because it's a purely statutory claim. And it comes from, we see so much about these deaths, the ones just happened in California. But there are things that happen just in ordinary traffic and happen with products and the like. And how do we pursue those claims? What's provided? How do you calculate the damages? What are the rights to the individual survivors and loved ones that individual have? And what we were talking about just before we went on break was the fact that time is not on your side as a potential plaintiff or an heir or a loved one who wants to bring a cause of action. And it's because there are more things other than just simply the statute of limitations. There's also a statute of repose that all states seem to have, depending upon different types of products claims, whether there's a breach of warranty claim and the like. And so what I was beginning to get into was the example of, let's say that you have a terrible car wreck situation, an individual is killed, so you set it up for a wrongful death cause of action, and you think you've got either a 1 year or a 2 year statute of limitations. Well, that's not the end of the inquiry for your lawyer, because depending upon when that car went into use in the marketplace and was actually sold to be put in the marketplace, can affect the running of the statute of repose, which effectively is the timeline upon which you can at any point in time sue over that product. And for example, I know I had a case several years ago where there was an individual who was in a horrible one-car car wreck where the car turned on its side. There was a malfunction that was a known defect with the carburetor, so that the carburetor continued even though the car was wrecked and on its side, continued to pump fuel. The car caught on fire. The carburetor was still pumping fuel, so the fire just kept getting higher and higher and burned the driver of the car to death, and with such flames that the fire department, who was on the scene, could not even get in to help. There was no way to put it out because the flames continued to be fueled by the carburetor. And the problem is at that point in time, there was a 10-year statute of repose on the product, and that car had gone into service, i.e. had been first sold by the manufacturer 3 months beyond the 10-year statute of repose. So that even though we were only 3 months from the death and the horrible accident and the burning, it was barred because of the statute of repose with respect to those claims.
So here we are today talking about these topics, callers. If there are any callers, please give us a call at 800-8949. Listeners, we appreciate you listening. If you want to talk about these issues privately, give us a call at our office, 756-6400. be pleased to talk with you about the applicable statutes of limitations and repose and how those play in your case. You think you've got one?
And, you know, we were talking a minute ago about what types of individuals have claims and what kind of claims can be brought, you know, and we acknowledge that under the wrongful death statutes in most states, you're talking about either a surviving spouse or you're talking about children, whether minor or major, of age or not of age. It doesn't matter. They can bring an action through a representative if they're minor. They can be brought by a parent if there's not a spouse or a child, or if it's a child who was killed. But that's not the extent of where you want to. And of course, it can be brought by a representative of the state. And oftentimes, the representative of the state is the better choice. It's because you get into the case and you find that there were claims that occurred immediately prior to death. Not only the pain and suffering, because it was, as you get into the case, you learn that there was not an instantaneous death, but maybe there was a treatment and a lingering for an hour or 2 hours, maybe even before they get to the emergency room. So that they're pronounced DOA when they get to the emergency room, but they actually lingered and suffered at the scene for a good bit of time. Or in some states, there is a pre-impact horror or fear of death claim that exists. I know Georgia and North Carolina both recognize a situation where you can imagine in a situation if you saw the tractor trailer coming at you and had time to know that there was fixing to be a horrible impact that could cause your death, and the fear and horror that you would go through in those few seconds before it happened, or if you knew someone had a gun pointed at you in some of these shootings, and the realization that you were about to leave this earth and meet your maker and no longer see your children, you know, the horror and the fear and the anticipation of death that would happen. Well, some states recognize those claims, but they cannot be brought as part of the wrongful death act scenario where you're talking about maybe a parent or a child trying to be the plaintiff, because those are claims that were pre-death. And so in those situations, you've got to have a personal representative of that decedent's estate bring that action, whether it be a executor or an administrator. They're the ones that hold those claims that are pre-death that individual would have.
Now, Jim, we were talking before about who you can sue. We talked about the general topic of suing someone who's negligent or someone who intentionally caused you injury. But, you know, there are other limitations, like, for instance, in workers' compensation situations. If someone, for instance, works, and that's a general topic, workers' compensation. For instance, if you worked on the ocean, you might have to file your claim under the Jones Act, or if you worked, if that's against your employer or the ship owner. But if you work for the railroad, for instance, you may have to make what we call a Federal Employers Liability Act claim. Or there are the limitations. For instance, you can't necessarily sue a gun manufacturer for the purpose of demonstrating that the product is defective, because there's a law that prevents that sort of action. So, you know, it's not necessarily as simple as we made it say the first time that we talked about this first half of the hour. There could be limitations, but that's why you need expert assistance in making these claims.
Right. So if you're in a situation where you've lost a loved one, contact counsel early and often to try to see what your rights are before they expire. You don't have to call our firm. I mean, this is just a service in this station. The purpose is that we alert you that you can't sit back and you can't just rely on someone telling you, well, Tennessee's got a 1-year statute of limitations. Well, that may be true, but there may be a statute of repose running next month. You just never know until you have counsel look at the issues you've got and determine whether or not you have a claim.
So we were also talking about, certain circumstances that pop up in these cases. And one of the things might happen, what if the person who was involved in causing your injury is dead or no longer is in business as a corporation? What do you do then? How do those things operate?
Well, and, we do have ways of bringing the cause of action. We talked briefly in the prior half hour. If you've got a situation, most traditionally a situation in a car wreck, where not only do you have someone in your family killed, but the at-fault driver was killed as well. What do you do? And especially if they've not set up, if they've set up an estate, then what you do is you bring the action and name the personal representative of the estate, whether again administrator or executor for that at-fault driver. But if they haven't set up an estate, then there's a procedure whereby you can set up an administrator ad litem, and you're actually opening an estate solely for purposes of litigation of the tortfeasor. So you've got a stakeholder to receive service of process and to notify any applicable insurance carriers, as well as to notify any potential beneficiaries or transferees of their assets of the fact that there's a claim of a creditor, i.e., that the family or the loved ones or the estate of your decedent who are bringing a claim.
Well, we've had these kind of cases come up before with regards to corporations, and when corporations many times buy and sell each other, the great example here is the asbestos litigation. You had a number of businesses that had gone out of business and subsequently became insolvent as a result of the asbestos litigation because of the tremendous harm that were done to individuals who were exposed to that very dangerous product. And as a result, there were funds that were set up. And those funds, while the company itself may not be extant anymore, lawsuits were able at least to gather together, garner a huge pool of money, and that money was used to pay out claims. And so that's one way that you can address problems of insolvency with corporations that cause you injury. The other thing is, and we're involved in some of this now, we're dealing with a case that involves with what we call multi-district litigation. That's where there are rules set up in courts that allow for groups of cases to be consolidated in one court. And for that litigation, rather than to cause the demise of the business and therefore really endanger the ability of claimants to make a claim, they have a way to manage that.
Right. And not only do they manage it through the discovery process and the exchange of information between the plaintiffs and the defendants, but they also are able to manage it from the standpoint of hopefully, and we're not at this point yet, but hopefully an omnibus settlement. Or what they'll do is, I use the term strike, but they basically set up characteristics for various types of cases and settlement ranges. And then there are ways to try to resolve these cases in an expedient fashion where you might not get what you would have gotten if you tried the case with the jury, but you're able to get a settlement that is in the fair range of settlement and leaves monies available for all claims because there's just too many. Otherwise, you're in a race to the courthouse.
So what do we do about the cases involving mass torts? There are several times where large corporations may have caused the release of a chemical. I know we had some recently up in Cleveland. We've had this kind of accident occur in Louisiana before, release of sulfur dioxide, killing a number of people. You can bring lawsuits on behalf of all of those potential plaintiffs against that defendant, can't you?
Sure. You could bring a class action where you have a representative class set up and you have a hearing to make sure that the class can be established. And then you can go forward with the class action that type, or you can file. I know in a lot of a factory explosion type cases where you've got what effectively is a mass set of injuries among maybe 40 to 50 people. A lot of times that's not a class action, but that's just a huge cause of action where you may have 30, 40 plaintiffs all together brought in. So it really depends upon the cause of action and what's the target and the cause of the injuries. But you can bring both.
Jim, we got a peculiar situation in the law that allows us to bring a lawsuit for preservation of testimony in anticipation of a plaintiff who may not survive.
Right. I agree with that. That's you've got a potential wrongful death claim coming, but the foreseeable decedent has not yet expired, and yet you cannot get the cause of action filed in time, and there are various reasons for that, but as a result, you need to try to preserve that evidence before it is lost. And we've had that for years and years. It goes way back in our jurisprudence. We had bills to preserve testimony that we used to be able to file in the old courts of equity. And now that we're now under the rules of civil procedure in Tennessee, we've got what's called Rule 27. And you've got some familiar with Rule 27.
We do. Really recently, we've been involved with Rule 27, and it's a very strange set of circumstances for an attorney to file an action in anticipation of someone's death for the purpose of preserving that testimony. But, in today's age, a lot of folks used to be said that folks, in terms of medical care, you died almost always of a myocardial infarction. You always had a heart attack. But that's not true today. We have the ability to stop people from dying of heart attacks, but they die of other things. And unfortunately, cancer is one of them. And so that sort of thing usually lingers and takes a while. And while you may have a reasonable anticipation that that person is not going to survive, there are other diseases that are the same. But, in that set of circumstances where the injury is caused by someone or by an entity, you've got to be able to make sure that that person has a voice and gets to speak, even after they may not be alive to see the case actually filed.
Right. And it's not necessarily just the fact that there's an anticipation of death. With the treatments that these individuals go through, there's a loss of the ability to recall. There's a term of art being used by some of the physicians today, and I know there are a lot of studies being done about what they call chemo brain, where extensive chemotherapy can actually impact the personality of the individual that's going through extensive chemotherapy, as well as will impact their ability to recall. If you've had a loved one that's gone through cancer treatment and chemotherapy, you may have seen some of the differences and the awful time they've had going through chemotherapy. But the treatment itself, while it's life-preserving and life-saving in many situations, or at least extends the term of life for many individuals, its side effects have a cost.
Well, and so that situation may come up, and the law's made preparation for it. So we're here talking about wrongful death cases. It's 800-8949. We're at the law firm of McKoon, Williams, Ashton, and Stanley. Phone number 756-6400. If you have a topic you want to talk about outside of the radio broadcast, otherwise, give us a call. We'd love to talk about any topic. We're here today about talking about a number of different issues. We've had callers already today. We'd love to hear from you.
Yes, we would. And from the standpoint of the wrongful death claims, Clay, I know you've got a lot of experience in bringing those. Who all do you have as your plaintiffs? And let's assume there's an estate set up. Do you bring just the action in the name of the state, or who else do you bring in?
Well, and so that can end up being in the names, and primarily we've got situations where you may have claimants as next of kin who are children. And so I think that's one of the potentials, at least, as the personal representative may also have to represent the interest of minor children. And so that's in all of the states, I believe, that still has the application. It's a common situation that comes up. And we've got that going on in our office now, where we've got children that are being represented, that have been deprived of their parents and not going to have the ability to receive the economic support from their parents because of the unfortunate demise in regards to an accident.
Right. Or we've had the situation where a child has been killed. And so you bring the action. You normally don't have an estate for a child because they don't really own anything. And so or owe anything either. They usually don't have creditors because the parents are taking care of them. So what you end up with is you have a cause of action generally brought by the parents, not only as the parents of the child, that qualifies them for the purposes of the Wrongful Death Act, but they also bring the action individually for their own individual loss to consortium with the child, the filial consortium we talked about it earlier, so that they've got the claims for not only the economic value of the loss of their child, but they also have their individual claims for the loss of the love, affection, and services, and the total global relationship between them and their child.
Yeah, this is a difficult topic, Jim, and it always ends up being one of those things that is fraught with a number of emotions that come with the dealing with this particular thing. That's something attorneys have to deal with in the course of your practice, and that is to handle people and understand the sensitivity that's involved in these cases.
Yeah, and that goes to, if you're working with an attorney, or if one of these situations come up, trust your attorney. There's a lot of information we get in the course of investigating and discovering cases, photographs that we get from the scene of an accident. You do not need to see. Just trust your counsel that he's received the photographs, that he's reviewed them, that they're beneficial. But there are so many times I've had situations where my clients just did not need to see their loved ones in their last moments or right after the last moments, as they may have been photographed at the scene, because it's just not the kind of loving and caring thing that a parent needs to have as the last memory of their child.
That's all true, Jim. So again, we're coming to the close of our half hour, and if the key thing, I think, if we could sum up today for people, is to understand that time, like you said, is not your friend. In these cases, you need to contact counsel. You have questions about the cause of injuries, a number of things in this world that cause the death of persons that may not be apparent at first, and you might want to talk with a lawyer about whether or not you make a claim.
Absolutely. Plus, evidence is lost. Evidence from the scene of the accident. Witnesses die. Witnesses, their information is lost. They've moved. So the sooner you can act after a tragic event, the better, solely for the purposes of trying to preserve the evidence that you're looking for. Well, this has been another edition of Legal Bytes. Clay, it's moved by quickly. I've really enjoyed talking about this topic.
Me too, Jim.
And listeners, thank you for joining in with us today. And we'll talk to you next week on the next edition of Legal Bytes.
Chattanooga Radio, digital FM 95.3 HD4, 92.7 FM's news. Now,
A major drug bust in the Chattanooga area. The Lookout Mountain Judicial Circuit Drug